Good evening. Welcome to the Show Justice of the Peace Candidate Forum. My name is Bob Higgins. I'm a former presiding judge of Navajo County and current Pinetop Lakeside Justice of the Peace. I'll be your moderator tonight. Welcome to the candidates and the audience. Choosing a judge to rule on cases and issue judgment should be an informed decision for the public, and tonight is your opportunity to listen to the Sholo Justice of the Peace candidates and to hear their thoughts and views on being a judge so that you can cast an informed vote. Before we begin tonight, I'd like to remind the audience to please turn off all cell phones and personal electronic equipment. And our sponsors tonight are the Navajo County Bar Association, which is a nonpartisan organization of attorneys practicing in Navajo County. It believes that it's important for people to learn about judicial candidates in Navajo County so they can make an informed decision. I realize that many people in the audience tonight may support one candidate or another. However, I'd ask that you'd hold your applause or boos or whatever it may be till the very end of the session. And also to the candidates, of course, it's just a chance for the public to get to know you. And so this is a good time to talk about yourself, but not each other too much, just yourselves. The timekeeper for this evening's forum is Brad Carline, our county attorney. Thank you, Brad, for doing that. And he will hold up a card for you to know how much time you have left. The format for the evening is that each candidate will do an opening statement, and then they will answer questions and finally have a closing statement. Each of the opening statements and closing statements will be 3 minutes, and the time for answering each question is 3 minutes as well. I'd like to introduce in alphabetical order the candidates tonight: Scott Tipton and Don Wilson. It's time for our candidate's opening statement of 3 minutes, and we drew lots, and Ms. Wilson will go first.
Thank you. I am Dawn Wilson, and as you know, I'm running for Sholo Justice of the Peace in Precinct 5. I have lived in the White Mountains for 23 years, and I've lived here in Sholo for 21. I have one 22-year-old son, Cody Gonzalez, who is my gift from God and the light of my life. He's here in the audience with his beautiful girlfriend, Mariana. Cody grew up in Sholo and attended the Sholo School District. Also in the audience is my beautiful mother, Sharon Stone. Yes, Sharon Stone, that's her, sitting right there. I want to tell you about my education. I have a Master's of Science in Administration of Justice and Security with an emphasis on law enforcement organizations. I also have a Bachelor's in Criminal Justice and Human Services. I have worked in the criminal justice field for 25 years. I'm a prior law enforcement officer and a prior investigator for the state of Arizona. I'm a small business owner here in the community. I'm a licensed private investigator. I have my own private investigation agency, and I'm a board-certified criminal defense investigator. And I spent years working with the Navajo County Public Defender's Office. Also worked for Apache, Coconino, and Mojave counties as a contract investigator for defense attorneys. I am the West Director of the National Defender Investigator Association and the chair of the Arizona Public Defender Investigator Association. I am active in our community. I am the president of the Sholo Lions Club, and all of our fundraising goes back to the community. And one of the organizations that benefits from that fundraising is Teen Court. Teen Court is right here in Sholo in these courts. I serve as a consultant criminal justice coordinator to the Navajo County Criminal Justice Coordinating Council. We work as a team, and we work hard to bring resources and programs right here to Navajo County. I recently became an auxiliary member of the Sholo VFW, and I look forward to working with them and improving programs for our veterans. I mean, God bless our veterans. There's not enough services up here for them. I also served as a Sholo City Councilwoman, and I only stepped down due to the Resign to Run law here in Arizona. I was appointed as a board member for Meals on Wheels and to the Public Transit Committee. I have also served on the City of Sholo Planning and Zoning Committee prior to becoming a council member. So I have the right experience and I am the right choice for this position. Thank you.
All right, thanks, Ms. Wilson. Mr. Tipton.
Thank you. I'd like to thank the Navajo County Bar Association and the City of Show Low for allowing us to use their facilities here. They're very nice facilities. My name is Scott Tipton. I'm running for Justice of the Peace here in Precinct 5. And Precinct 5, if you don't know, encompasses Clay Springs, Pinedale, Linden, Show Low, of course, and White Mountain Lakes. I'm an Arizona native. I grew up in Tempe, Arizona. I was able to attend and graduate from ASU. Spent some time overseas teaching English as an English teacher. When I returned to the States, I got a job as a police officer in my hometown police department in Tempe. Due to an on-duty shooting in which I was severely injured, I had to retire early from that particular position. So I'm a transplant to Show Low. In 2006, my wife and I and our 3 kids decided to move up here to Show Low. We wanted cooler weather as well as a good place to raise our 3 kids. At the time, I was a real estate agent. That's what brought me up here, was real estate. And then in 2009, when the real estate market kind of crashed, I went back to my roots in law enforcement. I worked for Corridor Community Services as a private investigator and as a process server. And in 2010, the constable, Ray Brown, which many people knew and loved, he decided he was going to retire. So I thought I would run for that position of constable. It seemed to be a good fit with the process serving background I had and the law enforcement background I had. And I won. I won that position back in 2010 and began my tenure as constable in 2011. So I worked in the Justice Court now for 3 terms. I'm a proven elected official, proved to be accountable and responsible in that position. I am a conservative. And when I say a conservative, I mean that I believe our country is unique, bastion of liberty, that the federal government should be small, should not interfere in the lives of ordinary citizens. We should stick to watching the borders, tariffs, not managing the economy, and staying out of that. We can see the results of a meddling government, I think, right now. As a constable, going back to a constable, I've served on 2 state boards, the Arizona Constable Association, as well as the Constable Ethics Standards and Training Board. I hope to touch on those a little bit later on. So with my experience and beliefs, I believe I can serve Show Low well as Justice of the Peace. So I hope by the end of this forum that the viewers will also agree with me. Thank you very much. Please, agree with me and vote for Scott Tipton, Show Low, Justice of the Peace. Thank you.
All right, thanks, Mr. Tipton. And the first question goes to you. As a prospective judge, what are your greatest strengths and weaknesses?
That's a good question. You know, no one likes to talk about.
I just wanted to start off with an easy one.
That's an easy one.
Yeah.
Okay. If you're talking about strengths, we'll hit those first. I believe my time as a constable and as a law enforcement officer and the training I received in that capacity really helps. I was trained in conflict resolution. I've also been trained in civil and criminal law. As a constable, we have 16 hours required of us to be trained every year. I get more than that. Usually I get close to 30 hours of training every year as a constable. I believe I'm a good listener and I'm patient. I will be able to listen to people who come before the Justice of the Peace with their problem. I mean, people want to have their say in court, and I believe I'm good at that. The other thing that I think was vital, and neither of us have been judges before, but I got pretty close working on the ethics board. I was the chairman and the vice chair on the ethics board. I served 4 years on that board, and the board has 2 jobs. One is to mete out grants. Constables will apply for grants and will decide if they meet the criteria. The other is to listen to constable complaints from throughout the state. So if a citizen complains against a constable, it will come to the Constable Ethics Standards and Training Board. And then on that board, which comprise of normal citizens, a judge, sheriff, and 2 constables, we'll listen to that complaint. We'll decide if it has merit, and we'll investigate further. If some punitive action needs to happen, like a letter in this constable's file, all the way up to telling them he should probably resign for this, or telling their board of supervisors, you should probably fine him or dock his pay or make sure he gets time off without pay. That is something that I did for 4 years. And I think that really applies to the justice of the peace position. I'm well-rounded. I've not only been in law enforcement, I've also been a real estate agent. I've been a teacher. I've worked several odd jobs around. In fact, to prepare for this campaign, I worked for Sutton Weed and Pest Control, and in that way, I was able to save for this campaign because campaigns are expensive. I'm a scoutmaster, and that goes a long way with patients. I've had to manage up to 20 scouts. As far as weaknesses, I tend to work hard and neglect my hobbies. I'm a perfectionist. I want to get things done right, and I want it done the right way. That's the best that I can probably do. Thank you.
Thanks, Mr. Tipton and Ms. Wilson.
So my strengths are those skills that are supported through my experience. I started my career in the courts. My first job in criminal justice was with the Overland Park Municipal Court in Overland Park, Kansas, prior to becoming a law enforcement officer. And I worked there a couple years, became an officer, and then remained part-time for another 5 years with that court. Then, while getting my associate's degree here in Sholo at NPC, I did my internship in these very courts when Judge Patterson was a clerk, and I believe she actually helped to train me. And I remained as a temporary employee off and on for nearly a year, filling in for both the Pine Top and the Sholo Justice Courts when people were out on medical leave or on vacation. I have nearly 8 years as a law enforcement officer in Johnson County, Kansas, and several years as an investigator for the state of Arizona. But what I have is 10 years as a board-certified criminal defense investigator. So I have worked for both the prosecution and the defense. I can and will be fair and impartial. However, I also have many years working for civil attorneys. I'm a trained guardian ad litem. I am a guardianship, conservatorship, adoption, severance, probate, and best interest investigator. I know how to read and interpret statute. I have had to make recommendations in the best interest of a juvenile or an adult for where they're going to live, who's going to care for them, who's going to handle their money. And although my recommendation was not the actual decision, judges, it was weighty upon a judge, my investigation for that. I have testified in many court hearings. I have sat at both the defense and the prosecution table in criminal trials. I know how to ensure a defendant's rights are not violated. And through my experience, I can identify when a defendant's rights have been violated. I know that in seeking the truth, you have to get both sides of the story. You have to listen to both sides and make an informed decision based off the evidence that's presented in court and without outside influences. So those are my strengths, other than, obviously good communication skills. But my weakness is that I've never been a judge, but I can learn the job and I can learn the duties of the job. And I am confident that I can improve my skills through the education and continual training and on-the-job experience. And I'm not afraid to ask for assistance from other people. Thank you.
All right, thank you. And we'll stick with you, Ms. Wilson, for the next question. What is your general judicial philosophy? For example, what should a judge do and not do?
Absolutely. So my underlying ideas and beliefs are that a judge should be objective and neutral when hearing a case and when making a decision. I'm a conservative. I know that justice needs to be served and victims must be made whole. But I also know that recidivism needs to be addressed and that the underlying causes for recidivism, I hate that word, those issues need to be treated. But I want to go back for a second. Injustice being served, not all forms of justice are one size fits all. So we need to be creative. A judge should always remain fair and impartial, and personal opinions and politics should never be any part of any court decision. A judge should always ensure that a defendant's right to due process and their constitutional rights are never violated. I just think that if you can be objective, if you can follow the Constitution, if you can follow the laws and not deviate from them and not interpret them into some meaning that isn't what they were meant to be, that makes a good judge. And so that's my philosophy.
Thank you.
Thanks.
And Mr. Tipton.
Good question. Be a good judge. I agree with a lot of what Ms. Wilson has said. You need to take your bias and you need to check it at the door. You need to be able to come into that courtroom, no matter what's happened that day or what you think, because we're all human. We all have our own bias. But as the justice of the peace, you take that, you set it aside, and you look at the offense, you look at the statute, and you make a decision. If you don't know the decision, you ask for help. Justice should be served. That's one philosophy. The victim should be made whole. And on the other side, the offender, and as justice of the peace, we're kind of bound by the statutes. We don't have much leeway in some cases. Sometimes specific misdemeanors have specific fines attached, specific punishments attached. For example, DUI, you need 30 days in jail. How can that be served? Well, right now the Justice Court has its GPS monitoring program where a offender can remain out of jail and can remain a productive citizen by being monitored by a GPS bracelet. That's one thing that you can do as a justice of the peace. Sometimes you can be creative, sometimes you can't. Sometimes you have to go by the statute. That purpose is so that the offender can learn a lesson and not have any recidivism, as Ms. Wilson has said, and won't offend again. It's to just discourage them from going back and committing the same crime. So, in my opinion, justice needs to be served, the victim needs to be made whole, and the offender needs to learn a lesson. I think that's my philosophy. Thank you.
Great, thank you. Kind of as a backup to something you just said, so we'll stick with Mr. Tipton and then come back to Ms. Wilson. How would you handle cases involving unfamiliar law, something that you know nothing about, which happens? So that's kind of a practical question.
That will absolutely happen. Justice of the peace is not omniscient and all-knowing, especially coming in newly trained and coming in sitting on that bench for the first few months. There's Judge Price said it almost took him one whole term to get his judge legs under him, and it will take a while. However, you must humbly approach laws that you're not familiar with and research them, ponder them, and think about them thoughtfully. And then if you need help, there are Superior Court judges, and especially I hope you're around, Judge Higgins, which could really help out a lot. And using these resources that you have, then you can come to a decision. Of course, relying on the Constitution, making sure no one's rights are violated, that is a big part of it as well. But being humble and teachable and realizing that you don't know everything and you might have to take some time off to research a specific law and ask for help, I think that's a big part of being a justice of the peace. Thank you.
Great. Thanks, Mr. Tipton and Ms. Wilson.
Well, I know for me, I would not want to make a decision on the case if I was not clear on the law, if I didn't have supporting documents. If there were, you didn't say, but if there were an attorney in the case on one side or the other or both sides, I would ask them to present case law to support it. I would also look to research. I'm sure that the Bar Association has resources to do that, but I would ask that maybe we set the case off for, a bit so that I have a chance to review it. Or maybe I would hear the entire case and then take it under consideration and then research those laws and figure that out. ask the questions that I need to ask before I made any decisions. I would want to be well informed as to that law. And as Mr. Tipton said, there are other judges that can be consulted. There are other attorneys that can be, possibly consulted. But the point is, I would not want to make a decision in someone's life, whether it involves jail, whether it doesn't involve jail, or anything like that. If it's a civil case and it's a law I don't know, I don't want to make that decision until I'm informed. So I think in the best case, I would ask them to present anything that would support their cause, and I would take the time to research it before I came to a decision.
Great, thank you. All right, so we'll stick with you, Ms. Wilson. In Shola, there's a teen court. Tell us what you know about teen court, and if you like that concept, or if you plan to keep it, or do away with it.
Absolutely. So, as the president of the Shola Lions Club, I've recently become the president, but I've been a member of the Lions Club since 2010. I know that teen court has been around since, I believe, before or when Judge Price was first a judge. I think that he and Phyllis Clark from the Lions Club maybe helped to get that going, but or I take that. I think the judge got it going, but Phyllis Clark got involved as far as scholarships for the teen court. And so what I know of it is that the teens that get in trouble, they can be sentenced to that court. And it is a jury of their own peers. It is a jury of other teens that have been in trouble and gone through the court. And when you get in trouble and you go through that court, then when you get out of it, I believe you have to serve on that court. So you have to do your time within that court as well. And so some of these teens that go before the court, they get harsher sentences than if they would have gone before the regular criminal justice system. But it has been successful. It has turned a lot of people around. It is very much creative sentencing, from my knowledge. And I like it. And I think that it should remain in place. And as these teens successfully graduate the court, then there are entities and other organizations that will provide scholarships to them to help them with college. So that's what I know of it.
All right. Thanks, Ms. Wilson. Mr. Tipton.
Well, I've sat in a few of the teen court meetings, and it's really interesting. The jury's made up of teens. Prosecution is a teenager. The defense is a teenager. And it's a great program. It exposes, I think, the teens to court without it being really, really scary. I think it's their friends from high school. Like Ms. Wilson said, when someone gets in trouble, they're a teenager, that's an option. It's a diversion. And if they can complete the teen court process, then that let's say it's a traffic ticket, and that traffic fine will be done away with. They get to go before the teen court. The jurors in that process will go ahead and figure out a sentence related to the crime. And there are some crimes that can't be held in teen court. I believe shoplifting is one of them. Anything to do with alcohol is another one that they can't hear in teen court. But everything else they can hear. And usually the sentence involves an essay, some community service, and they have to come back and serve on the teen court. And when that's done, their sentence is basically the slate's wiped clean. I think it's a great program. The school resource officer usually attends. A counselor from the school attends. And it's been going now since Judge Price implemented it. And I think it's a great program. I will definitely continue that if elected as Justice of the Peace. Thank you.
Great, thank you. All right, and we'll stay with you then, Mr. Tipton. We've talked a lot about criminal cases. If you had a civil case, justice courts have jurisdiction up to $10,000 in civil cases. What would be different about that or would it be different as to how you would approach a case like that?
The basic approach is the same. You want the victim to be made whole. Okay? You want justice to be served. Because there's no criminal charges pending, you've really got to listen. You've got to listen to these cases. Someone is probably not going to be happy at the end of these cases. Usually, it involves money. Sometimes it's items, but as far as the justice court's concerned, you can't command anyone to give back a certain item. You have to make them whole monetarily. From what I understand from other judges that I've spoken with, civil is a whole different monster, whole different ball of wax, and it takes a lot of consideration, it takes a lot of research, and a lot of experience. One judge that I spoke with said, I knew criminal law. He was a former police officer. Civil was really hard, even though he had been a constable. He said the civil was really difficult for him to get a hold of. So I plan on listening to the training, but approaching it in the same way. I'm going to listen. I'm going to be patient, hear both sides out, and decide for the preponderance of the evidence, who's right. And you don't have to make a decision right then sometimes. Sometimes you can go back and research and give your decision in a few days. That might be the case here at first. But if I can't find the answer, I know the resources to go to find it. But that's how I would approach civil cases.
Great. Thanks, Mr. Tipton. Ms. Wilson.
Well, he said it all. So as a judge approaching the civil case, I think that it is important that those cases that come before you, I would hope that as a judge, I would know that case was coming up ahead of time and I would have a chance to kind of review what it's about. But listening to both sides of them, I mean, we need to know what each side has said. One side is correct and one side is not. So you have to judge who is actually in the right and who is actually in the wrong. And we have to remember that civil cases at $10,000, also that does not include, I believe, the attorney's fees, any fees for filing the case and stuff. So that case, that $10,000 is only for the restitution or whatever for the person that wins the case. But you have to research it. If you're unfamiliar, again, it's taking the case under consideration after hearing both sides, after listening to both and trying to make a determination of who was in the right, who was in the wrong. And before I would want to make a decision on that, I would take it under consideration and I would really do the research as to what the case was about, what law support it before I do any decision on it.
Great, thank you. And we'll stick with you, Ms. Wilson. We'll go back now to criminal law. I'm just following up on something both of you have said, that you'd protect defendants' constitutional rights. So as a judge, how would you do that?
Well, okay, so if a defendant comes in and they have a case that could get them up to 6 months in jail on a misdemeanor, or up to a year, but if it's a case that could get them jail time, I would see if they qualify for an attorney, a public defender. If they just came in and said, well, I just want to plead guilty, I just want to get this over with, I wouldn't let them do that, because I think that they need to be informed of what their rights are, what their options are. And I think that going ahead and saying, we're going to enter a not guilty plea and we're going to put this off. And, you need to think about this. You need to have time to hire counsel. Let me get you counsel, that type of thing. Because we want to make sure that they understand what's going on. But I also want to make sure that as the process goes through the court, that they have their right, if they're unrepresented, to have their witnesses testify, to cross-examine witnesses. I want to make sure that those court procedures are followed and they have every right to do the same as what the prosecution would do. So that's what I would do, is just make sure that they are protected. They have every right that anybody else would have. Fair and equal treatment across the board, whether you're represented or unrepresented.
Great, thank you. And Mr. Tipton, same question.
Okay. I don't know if a lot of people know this, but justices of the peace, they sign warrants. It's something that police officers will visit the judge now, and they'll go ahead and present their case, and hopefully there's probable cause there. That's Fourth Amendment search and seizure type of thing. You have to make sure that there's enough probable cause for the police, or you sign that warrant as justice of the peace that allows them to go in and execute that warrant, look for the evidence they're searching for. That's one way. And, much the same way with Ms. Wilson, what she said. I have seen Judge Price, I've seen Judge Patterson do this. When someone comes in, sometimes they're frustrated. They just want to, let's just get this over with. But if they have, possibly a case, then you don't want them to just throw away their rights so lightly, so rashly. And there's been some cases, especially with Judge Price, I've seen him do this. He says, I think it might be a good idea for you to meet with the county attorney. You'll be able to go over the county attorney, see what they have, and possibly get a plea deal. And, I don't want to legislate from the bench. I don't want to give legal advice from the bench. But you do have a little bit of discretion and leeway to do that to people, because as a professional, you're doing this every day. And so you get some knowledge there. And people that come to the court a lot of times don't have that. And I think being compassionate as a judge and knowing your options within the law of what you can advise people to do from the bench is a thing that I will definitely learn and will hopefully be able to exercise. Thank you.
All right, thanks, Mr. Tipton, and I'll stay with you. So we're here in a small town, Show Low, Arizona, and as a judge, you have an ethical standard, which is to avoid even the appearance of impropriety. But in a small town, you could be in Walmart or Walgreens or the car wash or church or wherever, and people will come up to you and ask legal questions. Or they might even say, hey, I have a case in front of you. Can I ask you a question? How would you handle something like that? And how do you think that's going to change your life a bit if you become the judge?
I get that now as the constable. People come up and ask me for legal advice, and I really can't tell them. I can't. In the scope of my knowledge as a former retired police officer and as a constable, you really can't advise people. That's for a lawyer to do. It's for an attorney to do. And I imagine as a judge, it would probably not get any better. I think people would, especially if you're friends and if you're approachable, people will ask you for your advice. And I heard before, don't talk shop outside of shop. Come into the court, talk to me in court, and I'll see if I can help. If not, I can't give you any ex parte or one-sided opinion. Then I'll have to tell you that, and I'll tell you that if you spill your guts basically and tell me about your case, I'm not going to be able to sit on the bench for that. I'm going to have to recuse myself for that. And so that's what I would tell people in a kind way. That's all I have. Thank you.
Great, thank you. And Ms. Wilson.
So I actually have experience with that, not as a judge, but as both the city, being on the City of Show Low Planning and Zoning Commission and being a Show Low City Council member. Many people have come up to me and wanting to speak to me about the issues that were going before the commission or the council. And, I respectfully let them know, that I can't talk to them about that because that would put me in a very bad position. And when it comes to voting on that topic, I'm up here, they're presenting. I can't vote on it in good conscience because I now have information that the other council members or commission members don't have, or I'm privy to, information that they don't have, and I have to disclose that person approached to me and withdraw from actually voting for that. So also working as an investigator, people have come up and want to talk about criminal cases, and we had the very major criminal case in November 8th of 2016, and I had people wanting to know information about it. And it's like, I can't tell you that. I can't disclose that information, if they're not involved in that case. So I know that there are things you can talk about and there are things you can't talk about. And, I've had people come up and want to tell me what their role was in a criminal case. And it's like, don't make me a witness against you. I'm not on your case. Don't tell me that. So as a judge, if someone came up and wanted to talk to me about it, I would just cordially tell them, I'm sorry, I cannot discuss this. This is not the proper format to do that. I cannot give legal advice. And that in speaking with them could cause me to have to recuse myself, from hearing the case. And I don't necessarily want to have to do that. So I would be very nice about it, but I would tell them that this is just the way it has to be.
All right, thank you.
Mm-hmm.
And kind of a follow-up question to that. and it might be a shorter answer here, but what's the appropriate demeanor for a judge? Say you have difficult people who come to you in court. That's a hypothetical, but you know, that happens. And so how do you handle that? They could be lawyers, they could be just unrepresented litigants. Do you get angry? How do you handle difficult people in court? And what's a proper demeanor both inside your courtroom and off the bench as well?
And that's for me.
Yes.
Oh, come on. I'm a criminal defense investigator. Oh, my clients are difficult. You know, I think that one of the important things to, when you're dealing with a difficult person, a difficult defendant, you got to look at and assess, why is this person being difficult? Is it because they're ignorant to the law and the court rules because they're not an attorney? Is it because they've had a really bad day, or that they really believe they've been wronged by that officer or this criminal justice system? Or could they possibly suffer from a substance abuse disorder or a mental disorder? And I believe that if you take the time to really listen to them, because most of them just want you to hear them out, listen to their issues, and then explain to them, you know, in a calmly manner, you know, with compassion, being courteous to them, that the rules of court still have to be followed, and that they will get their opportunity, you know, to present their side, but that the court still has to run in an orderly manner. And I have that ability to talk people down, maybe not all the time. I mean, there are people you just can't talk down. And I think if that's the case, then I think that that case needs to be continued until a different time when that person can come in and be respectful. You know, and whether that person is an attorney or a defendant, because I can tell you that I have seen both. So I just think remaining in the courtroom, remaining professional. Outside of the courtroom, you still have to remain professional. You still have to remain respectful, and just tell them, you know, this is outside the courtroom. This is not the proper place. Thank you.
Great, thank you. And Mr. Tipton, same question.
Well, it's going to be hard to answer. I just don't know any attorneys that would ever act like that.
Robin.
But in all seriousness, professionally, and I'm just probably going to reiterate much of what Ms. Wilson has said. To remain professional, not lose your cool. People want to be heard. They want to give their side of the story, and sometimes maybe they might not be used to telling it in a way that is tactful or diplomatic. Maybe they feel like they've been used and abused by the system. As long as they're not being crude or disorderly, then they have a right to be heard. Now, I've been in many cases where I've done court security for the Justice Court, where we have two sides in an order protection hearing. And the judge will always say before the order protection hearing, we are going to remain professional, we're going to talk one at a time, and we're going to be courteous to each other. We're not going to yell, we're not going to talk to each other, you talk to me, and I would continue to do that as Justice of the Peace. I've been trained in conflict resolution. I imagine I'm going to be needing that as a Justice of the Peace. It will happen. There will be those people who are aggravated and maybe even belligerent. And like Ms. Wilson said, sometimes it is a good point to reschedule that when there is only you and them in the court, so that they can let off steam. And maybe if they come back later, they'll have a different attitude and have cooled down a little bit. Thank you.
All right, thank you. And I'll stick with you, Mr. Tipton, and just kind of follow up on that a little bit. Often in justice court, you'll get unrepresented litigants who are angry to begin with to come into court, and they don't know the rules of evidence. They might file the wrong motions. And so they come in and it's already an agitated or heated situation. How would you handle something like that? It happens fairly often in justice court. That's kind of a follow-up question to what we were just talking about.
If you're talking like there's a pro se litigant, someone who is not represented by an attorney,
yeah,
and the other side does have an attorney.
You could have that situation too. Yeah.
Okay.
Yeah.
Okay. You know, everyone has the right to attorney. Whether they want to pay for it or not is another issue. And if one side looks like they are more prepared and able to proceed, I would give that, the agitated person, a chance. Do you want to have an attorney? Would you like to proceed? In the end, if he doesn't want to get an attorney, you're just going to have to go forward. And you do the same thing. You let them have their say, as long as they're not being out of line, disorderly, rude, belligerent. They have the right to their opinion and to present their evidence, as does the other side. And at the end of the day, you take both sides and you look at the evidence, you apply the law, and you make your decision.
Thank you. And Ms. Olson?
So I have to respectfully disagree. I'm sorry, Scott. But if the prosecutor is not seeking jail time, I do not believe that that person has a right to a public defender. Now, unless that's changed, I believe that they don't. But in situations like this, when you're dealing with an unrepresented person, you have to be patient, and you have to guide that person, through the process, probably a little bit more than you'd have to guide an attorney through. But, well, you shouldn't have to guide an attorney. Sorry, there are some attorneys maybe, but for the most part, you don't have to guide attorneys. But, you can't give them legal advice, but you can give them their options, so as to keep the court process moving. I'd said that earlier about you want to make sure that it keeps moving because you get bottlenecked and you're going to be there all day. But suggesting a possible continuance so that that individual may go obtain advice from counsel or assistance from a local legal aid so that they can get better prepared for, maybe the next hearing. But unrepresented people, a good portion of the time, I think, are just ignorant to the laws and the court processes. And I don't mean that in a bad way at all. I just mean they don't know that. They don't know the rules of the court and court procedure. And so even suggesting that they maybe go online and pull that up so that when they are at the next hearing, they do know. But I think just taking the time to explain to them that information and that they should seek, maybe suggesting that they seek some advice. That's what I do.
All right, thank you. And I'll stick with you, Ms. Wilson. So if you were elected to be the Show Law Justice of the Peace, how would you ensure a smooth transition? Are there any changes you would make right away? What would you do if you were elected?
Well, fortunately, I have been working with Navajo County since 2010, and I know a large number of the employees, and I know our organization. Assimilating into the culture and environment of the Justice Court would be a priority prior to taking, office. I think that going in and working with Judge Patterson or working with the clerks and see what they do, things have changed since I worked in the court. It was quite some time ago when I got that degree. And I know that the systems have changed, the court systems themselves. So I think really getting in there and getting to know them. But a key component is communication. And I know that my philosophy, my goal, and my visions need to be communicated to the staff. They need to know where I stand. They need to know what is changing, what is not changing, who is going to be impacted, how they're going to be impacted by it. Historically, people don't like change. And so I feel that one of the first things I would do is speak to each staff member individually and privately and find out what the issues have been for them with the job, what he or she believes could be improved upon, or what their personal goals are, and what change they would like to see. Making people feel important and giving them a voice makes a really huge difference in any transition. So for me, that's what I do, is assimilate myself into that environment prior to, so that people can get to know me.
Great, thank you.
Mm-hmm.
And Mr. Tipton.
I think that's a great question. When you have happy court clerks that get along well together, it really helps with the flow of the overall process. When people come in, people don't realize that. They don't see the behind the scenes. But you definitely know if there is some friction in the as far as back management goes. I've been in the court for 12 years, been in that justice court for 12 years. I know what the court clerks do. I respect them immensely. I don't think they get paid enough for what they do. Leadership change is always hard. It's always difficult no matter what. Even though the court clerks know me in my capacity as a constable, they don't know me in my capacity as a justice of the peace. I imagine there will be some growing pains, some bumps along the road. However, as I am already in that culture, I know those court clerks very well. We get along well. And I imagine it would be a smooth transition. I'm sure some things will change. I don't plan on making very many changes, or if I do make changes, it'll be small ones. It's not broke, you don't fix it. I think Judge Patterson has put together a very efficient and well-run justice court. Thank you.
All right, thank you. Mr. Timekeeper, do we have time for one more question? Okay. All right, I'll stick with you, Mr. Tipton, and I'll make it one that can probably be a little shorter because we're coming up against time for your closing statements. What are your thoughts about how bail should be set? Because that's a very practical question that we see all the time in justice court.
When you're looking at offenders and you're looking at them through the TV, sometimes it's a little impersonal. When you think of bail, I think one thing you have to consider is the severity of the crime. What has this person done? Are they a flight risk? Take that into consideration, I think, when setting bail. You don't want to set a necessarily high bail, and violate their constitutional rights that way by making it impossible for someone to get out of jail and remain a productive citizen. But you don't want to set it too low so they'll get out and offend again. This is something that I believe I'm going to have to rely on my training as a judge, and I'll have to rely on advice from others. I can't answer definitively right now. I know it's an important issue, and one that I think that I can learn as a justice. Thank you.
Great, thank you. And Ms. Wilson?
Well, so I think that bail, it needs to be a fair bail. It's kind of like sentencing. It needs to be a fair sentence. And so there are people that you just know if you let them out, they're going to go reoffend. And so perhaps with that bail, maybe it's not a cash bond, or maybe it's a security bond or something like that, something that might make it a little more difficult for them to actually post it. But I do think that unnecessarily high bonds are very unfair, and they do, as Mr. Tipton said, violate somebody's rights. I have seen people that get $500,000 bails for having credit cards in a credit card machine in a vehicle going down I-40, but you're charged with murder and your bail's less, and that's just my experience in being in this system. So I just really think that the bail needs to be fair. So that's how I answer that.
All right, thank you. One more question? All right. And so we'll kind of follow up a little bit with that. You touched on it. What should be your goal if you were elected as a JP in criminal sentencing?
Me?
Yes.
Okay, well, the sentence needs to be a fair sentence, and it needs to fit the elements of the crime. So mitigating and aggravating factors should be considered with sentencing. I believe that obviously justice needs to be served. I've said this a couple times. Victims have to be made whole. But also, I want to touch again on recidivism, because that needs to be addressed and the underlying issues need to be treated. So many crimes have an underlying issue, such as alcohol, drugs, prior abuse, mental illness. And if a defendant is eligible and willing to participate in a specialty court diversion program, and if the victim agrees, then I believe we need to give him or her that chance to change their life. Harsh penalties in jail are not always the most effective punishment when dealing with somebody who may be seriously mentally ill or have a substance abuse issue. The question is, can we save one person from being a repeat offender and change the capacity of that individual struggling with that addiction to get them to turn their life around and become a productive citizen in this community? If we can do that, how many more can we change through these specialty courts and through this creative sentencing to help them get their lives together? I think that that should be definitely a major part of a goal, is to get them to turn their life around. Some people, you can't always do that. Some people, jail is the only way and the only place for that. But other people, the underlying cause is that they just keep coming back because nobody's treated the issue. And so therefore, that's why I think that we need to allow them to enter into other programs.
Great, thank you. And Mr. Tipton.
Goal in sentencing is ultimately that justice is served. Laws without some sort of punitive measure attached to them have no teeth. Sentences in the justice court usually involve two things. It's usually monetary, a fine, or jail time, taking away someone's freedom. That's something that I will not take lightly, especially in today's inflationary economy. People are really trying to hang on to their money. Certain crimes require certain times in jail. DUIs. Domestic violence also requires a 26 weeks of counseling. Now, you can be a little creative with the counseling. If it looks like this person has an alcohol problem, suggest they go to Alcoholics Anonymous. If they have an anger issue, you can use a different sort of sentencing. One thing that I was really impressed with Judge Patterson, a young lady came before her one time, and during the sentencing, it was found out that she had not gotten her high school diploma. So Judge Patterson said, okay, here's what we'll do. How long is it going to take you to get your diploma? She said, well, if I take the classes, it'll take me 3 months. I said, okay, we'll see you in 3 months. You show me proof that you got your GED, I will suspend the fine. I thought that was absolutely amazing. So there are some options. However, usually in the justice court, you are bound by the Arizona revised statutes by law. And you're bound within those rules and those statutes. So sometimes we can't get as creative with certain kinds of sentences as maybe we'd like to be. Ultimately, the goal in sentencing is to make the victim whole, see the sentence fits the crime, and that the offender learns that from experience that this is something they do not want to do again. Thank you.
Great, thank you. And now it's time for closing statements. And so, Mr. Tipton, you'll go first on this, and then Ms. Wilson.
Thank you. Mm-hmm. I'm really grateful for the opportunity I've had to share my beliefs, experience, my qualifications tonight. I've worked as a constable in the Show Justice Court for 3 terms. In those 12 years, I think I have proven myself a responsible and accountable elected official. I've handled court fees, turned those in. I've done reports and logs and turned those in within the rules. And I've served on 2 committees that are state-run. I'm a problem solver. If there is a problem, I will find the solution. For example, the constables, they were lacking in equipment. I found grants and was able to get the constables the equipment they needed, from tasers, ballistic vests, the computers, and even trucks. You notice the constables driving around now, they all have trucks. I'm trained in conflict resolution, as well as other training that will help in my position as Justice of the Peace. I know the Justice Court. I've been there. The transition will be a smooth one if I'm elected. I know the court clerks. I know what they do. I'm well-rounded. I don't have experience in just criminal law. I have some experience in civil law. I have experience as a realtor in landlord-tenant law, which definitely comes into effect as a constable and as Justice of the Peace. If elected, I will be fair and unbiased in my decision. There will be no favors. There will be no personal vendettas. When presented with a case, I will study it out before coming to a decision. I will apply the law and use that as my guideline. I am teachable. If I don't know the answer, I will find it. I'm not above seeking help. So I will diligently and humbly serve the people of Precinct 5 if elected Justice of the Peace. So on August 2nd, please vote for me, Scott Tipton, for Justice of the Peace. Thank you.
Thank you, Mr. Tipton. Ms. Wilson.
Oh my gosh, I'm going to get in so much trouble. Earlier tonight, when I told you about my background, I recently got married. He's not here tonight because he works out of town. He is watching online. I married my soulmate, Ed Golden. I love you, babe. Sorry, I'll get in trouble for that. But I currently serve as the Navajo County Criminal Justice Coordinator. I've told you that. I'm the liaison between law enforcement, behavioral health, reentry, the courts, available resources in our community and across Arizona. I am actively working with our council to develop specialty courts and programs across our county, as well as diversion and deflection programs for individuals, whether they go into the system or they remain out of the system. So as a judge, I can continue to remain on this council, and I can be that person to implement those specialty courts. Here in Precinct 5, I can help to start those pilot programs and save the taxpayers money. These programs can address and heal the causes for recidivism that get our individuals, we can get those individuals in need back to being productive citizens. And we can start a road to change here in our community and throughout Navajo County. So, if I've said it before, if we can rehabilitate a defendant, and we still have justice served, we do. And I myself, I have well-rounded skills and the experience necessary to serve as the Show Justice of the Peace. I have the desire and the determination to represent the citizens of Precinct 5 to the best of my ability. I know the resources, I know the people, I know what our community needs are, and I have fought and continue to fight to improve our community and our community resources, and to build relationships with community members, our stakeholders, our partners. I have the experience in the criminal justice system. I am the right choice to serve as your next Justice of the Peace. So with that, thank you to the bar for putting this on. Thank you to Judge Higgins and to County Attorney Brad Carline for allowing us to speak tonight. And thank you to all of you who came in person and online. I really do appreciate it. Follow me on Facebook, Dawn Wilson for Show Justice of the Peace. Thank you.
All right. Thanks, Ms. Wilson. Thank you, Mr. Tipton. I'd like to thank at this time the Sholo City for allowing us to use these chambers. They're beautiful. Thanks to the Sholo TV and the Navajo County Bar Association, Brad Carline for volunteering his time as county attorney to be our timekeeper tonight. And I'd like to thank you, the audience, for coming and exercising your civic duty, and the viewers who also were watching this forum and getting a better idea of who to vote for so they can make an informed vote. Finally, I'd like to thank the candidates for your good discussion tonight, and I think both of you would make a great JP. And thanks for offering yourselves for service in our community.
Thank you.
Good night.